Okay, good afternoon, everyone. I hope you can hear me. I'm sorry if there's an echo, but we did have some technical difficulties. But today, we are talking about protecting your estate and inheritance. And my name is Elise Gross, and I do webinars monthly for the Presser Law Firm. We alternate between asset protection and estate planning topics. Today, what we want to talk about is just some basics about estate and how to protect your estate and how to protect your inheritance and your children's inheritance and other future generations. So let's start with an overview of the presentation. And at the end, we're going to talk about, if you're not already on our newsletter, our weekly newsletter, we do an e-newsletter, info@assetprotectionattorneys.com if you're not already on it, and we'll be happy to get you on it. We do complimentary preliminary consultations really can give us a call regarding anything, and if it's something we can help you with, we're happy to help you, and if it's not, we'll see if there's a way we can direct you otherwise. And if you're interested in any of Mr. Presser's books, please give us a call, and we can arrange for you to get them as well. Okay, so what are we talking about today? We're going to talk basically about how to plan your estate. What does that really mean? Updating your estate plan. When is that appropriate? We're going to spend some time on creditor proofing your estate plan, which leads us into preventing your children from losing their inheritance, planning for your spouse, planning for your incapacity, and then what about really one of your largest assets is going to be your business. So first, let's talk about planning your estate. Every time I look at the statistics, I'm astounded at what percentage of Americans doesn't even have a will. And I see it every day in my practice when I have clients who come in for the first time in their 60s and 70s and have never made a will. They've had children, their children are. It's amazing to me that it's the first time that they're really addressing this situation. Sometimes it's not a big deal because when you look at how they have their assets allocated and how they have beneficiary designations and what the Florida state law is in terms of who inherits if you have no will, it may not be the biggest deal. But sometimes it actually is a crucial difference from what they thought would happen. So I'm always happy to meet with people at whatever age to go through their assets, to discuss, what their options are, and most importantly, what does it look like now before they have any documents? Let me give you an example. Under Florida law, we have, if you do not have a will, it has to go through what we call intestate succession. And all that really means is there's a Florida statute, and every state has one, that says without your own planning, without doing your own will, here's how your estate would be divided at your death. So if you're married and all your children belong to you and your spouse, and neither of you has any other children from any other relationship, then if you die, your spouse will inherit all of your probate estate. Very simple. Anything that has to go through the court, through the probate system, because it was owned in your individual name, without a beneficiary, your spouse will inherit. If, on the other hand, either of you has a child that is not from the relationship, your spouse is only entitled to 50%. That might not be how you were expecting things to pan out. So it's important to understand what your estate intestacy laws are. While you're doing your planning, estate planning is really only one aspect of it. So what we do here in the Presser Law Firm, majority of what we do is asset protection planning, creditor protection planning, which is proactive planning to prevent future potential creditors from getting your assets. It's really an integrated plan. The estate planning and the asset protection go hand in hand, and really having one without the other is not a good thing. So you want to have both, and you want to address both when you're doing your estate planning. When you're doing your planning, you want to make sure that you're not going to have a situation where you're going to have an unintended beneficiary. So what does that mean? An unintended beneficiary might be the spouse of one of your children or descendants. It might be a creditor who your beneficiaries owe money to. It might be a creditor that your spouse owes money to. So when you're doing your planning, and we're going to be talking about this, you want to make sure that you're trying your best to prevent unintended persons from getting the assets that you worked so hard to obtain. So we do a plan, everything gets evaluated, and by doing a plan, your idea is to create a conflict-free and lawsuit-free estate. Is there any way to 100% plan for that? Absolutely not. However, we can do our best. We can put in provisions that will keep the trust going for a long period of time. We can make them very flexible. We can allow for the trustees to be able to make discretionary distributions and decisions so that hopefully they can prevent, even down the road, a lot of conflict and losses. And then finally, just as a byproduct, if you're doing a proper estate plan, you should be able to save estate taxes. I'm not going to spend a lot of time on estate taxes today. All I'll say briefly is, as it stands now, the exemption for each individual who pays U.S. taxes is over $11.5 million. So because of that, there's really not an estate tax problem for the majority of Americans right now. With that said, as things stand in 2026, that exemption is going to go down to about half if that law comes into play. Since we don't know what's going to happen in the government, we really don't know if we're going to end up at that place or if it's going to be changed, whether an estate tax will be repealed, whether the exemption will be lower. Really, it's up in the air right now. So all we can do is plan based on what we know and keep things as flexible as possible so that things can be changed. And that's critical when you're doing your estate planning. It's critical that you have a fluid plan that can be modified. So what if you already have a plan? Well, that's great. I'm proud of you. You've done obviously more than 50% of Americans. But don't just do the plan and forget about it, because the plan may need to change depending on how the laws change, depending on how the economy changes. Right now, I don't know when other people will be hearing this on YouTube, but right now we're going through the COVID-19 crisis, and people who 6 weeks ago had a lot of money may not have a lot of money anymore. They may be in a different health situation. They may have lost close family members who were beneficiaries. You have to update your estate plan. At this point, if you're home and you've got some free time, call your estate planning attorney and review your plan. And if you haven't already done a plan, now's a great time to get it started. But the idea is, as I said before, estate planning is fluid. When we create a plan, at least when I do, my idea is it took the client a long time to walk into my door. I want to plan for as many contingencies as possible, so I keep things very flexible. If it took you so long to get in the first time, I assume it's going to take you a lot longer to get in the second time, and I don't want you to be caught with a problem after a beneficiary dies or there's a change in circumstance. So by all means, revisit your plan after any life-changing event or every couple of years. but a well-drafted estate plan will be fluid enough that you should be in decent shape. We talked a little bit about intestacy before. That's when you don't have a will in place and you have to follow state statute. Depending on what state you're in, you should be familiar with what the statute says. Most of them are very similar, but there might be differences in the spousal share. There might be differences in, if God forbid your children are gone and it's going to go to the children's children, there might be some differences in how it's proportioned out. So I would be aware of what those laws are, but hopefully you're listening to this and you're going to do a plan and you'll be able to avoid that intestate law altogether. As we talk about the changes that are happening right now in the world, the value of your estate could have radically gone down, or there are some that are actually doing very well now depending on what business they're in. There are a few types of businesses that might be thriving in this, nightmarish, disastrous situation that we're in. But some lucky people may be benefiting. So your assets may be radically different than they were, again, 6 to 8 weeks ago. So we need to take a look at that. We need to reevaluate it. So your basic estate plan, if you're just starting, is going to be a will and or a trust. Generally, if you're going to do a trust, you're going to have a will as well, but you don't always have the trust. It's going to depend on what jurisdiction you're in, where probate is not difficult. You probably won't have a trust, or you may have a trust that you don't fund. For instance, I was talking to an attorney in Texas yesterday, and he was telling me that the probate process in Texas is very simple. So when they do a trust, they don't actually fund the trust until they fund it through the probate after the person dies. A lot less work for the individual while they're alive, and it doesn't seem to be a big deal when they pass away. Alternatively, if you're in the state of Florida, almost everybody has a revocable trust because our probate system is really, really not great. They're improving it every day, but it's legendary for being a difficult system. So almost everyone you meet, regardless of their financial wealth, is going to have a revocable trust because everyone is afraid of the concept of probate. So you're going to have your will. You may or may not have a trust. You're going to have a durable power of attorney, which is going to mean what we call an agent, to be able to make financial decisions for you. You're going to have going to be able to make medical decisions for you, and you're going to have a declaration naming pre-need guardian that if you ever do get declared incapacitated, a guardian would be appointed for you by the court, and this gives you an opportunity to inform the court whom you would have chosen as your guardian. You might have a living will, which states that in the event that you're no longer able to communicate and the doctors have declared that you're not going to have a quality of life, you're going to state in advance what your wishes would be to not have life-prolonging measures taken to keep you alive. You're also probably going to have what we call a HIPAA release. You've probably signed them 100 times at the doctor's office, but I like to do just one document that names everyone you've named as personal representative in your will, trustees, healthcare surrogates, agents under the power of attorney, and name them all in one document so that it's easy. When we talk about your estate and how you can creditor-proof it, before we even get to wills and trusts, we should talk about a few ways that you can take advantage of certain laws to creditor-proof your estate. So first thing you should always be aware of, and I'm skipping kind of down to almost the bottom, is what are your creditor exemptions in your state? So for instance, in Florida, and I actually didn't include homestead, which I should have, homestead property is a huge benefit in the state of Florida. It's not only great for getting some property tax reduction, it's also exempt from the claims of creditors. It's 100% exempt with the exception of under bankruptcy, and that's going to be a timing situation under bankruptcy, depending on how long you've owned the property, how much of your interest is protected. But let's just forget bankruptcy for the moment. Homestead would be protected in the state of Florida. So the only thing better than being an individual owning a homestead is being a husband and wife, spouses owning a homestead together under what we call tenants by the entireties, or sometimes it's tenancy by the entirety. There's different variations to the term, which basically means not only can nobody get your homestead because it's creditor protected as homestead, but under tenants by the entirety, no one would be able to get it anyway unless they had a joint judgment against husband and wife. So not just your homestead, but any property in Florida, or let me rephrase, because sometimes the property should, real estate should be in entities and maybe an LLC, but any asset in Florida, if you're married, you should consider and evaluate owning as tenants by the entirety. It's not the be-all, end-all, because if you do get a creditor who has a judgment against both you and your spouse, they can get through tenants by the entireties, but it is a good first line of defense. And if you combine that with ownership in protected entities, then you give yourself some extra protection. So it should be used, but it should be evaluated on each asset to determine whether it's an appropriate ownership. It is, however, only available to married people. And if you get divorced and you own something as tenants by the entirety, it immediately skips down to what we call tenants in common ownership, which means it doesn't even have a survivorship interest, much less being creditor protected. Kind of a subject for another day. I think I've done some webinars on that before, but just know that it is an option only if you're married. You can also consider doing some lifetime gifting to get some assets out of your estate, because if they're out of your estate, not only are they no longer added to your estate tax base when you die, but if you're no longer an owner and you transferred it at a time where you didn't have active creditors, then it's no longer an asset that's available to future creditors. So what you don't have, they cannot get. So you can use the irrevocable trust strategy to transfer assets out of your name to benefit from estate and gift taxes. There's different savings that you would have, whether it's discounting on the gift itself so that the value of what you're transferring is really less than what you think it is. So you use less of your exemption, your federal tax exemption, and any appreciation of that asset is outside of your estate. So that's a very good tool that you can use. The downside of the irrevocable trust is it is irrevocable, which means you can't change it and you have really not much control over it. With that said, you're able to change the trustees, and there are provisions that you can put in where you could technically control certain things, even if it's indirectly. You have to be very careful how it's drafted, but there are certain things that you can indirectly control as long as they're drafted properly so that a creditor could never use those clauses against you. You might also want to invest in other exempt assets, for instance, annuities. I'm not a financial advisor, so I'm not going to advise you on annuities. All I can tell you is that annuities that are purchased, if you're a Floridian, in advance of a creditor are exempt from the claims of creditors later on. So whether or not an annuity is a proper investment for you, that's between you and your financial advisor. But just so you know, the annuity is a protected asset in Florida as long as it's purchased before you have the debt. If it's purchased after you have the debt and your creditor has a clever attorney who knows this, then the annuity may not be safe. So it's part of proactive planning. Evaluate with your financial advisor. Same thing for life insurance. Life insurance and their proceeds are protected. In fact, life insurance is actually a really great asset because it's asset protected. And when you die and it pays out, the beneficiaries take it without any income tax on it. There may be estate tax consequences depending on how the life insurance is owned and who owns it. But it is a protective asset, and it can be used for many different facets of an estate plan, whether it's to pay for the estate taxes you'll ultimately have to pay, whether it's just to provide liquid assets to buy out somebody else at the time of death, whether it's to use to borrow against if it's got cash value. So there's a lot of different facets to it, and you can use it as part of your estate planning. So how do we keep our kids and our descendants from losing their inheritance? Well, the first thing I would tell you, and it might sound harsh, is don't give it to them. And what I mean by that is don't set your estate up so simply that when you die, your beneficiaries just get the money outright. Yes, it would be simple. Yes, it would be less costly, and it would probably create less drama. However, understand that once somebody gets money, it's theirs. That means if they had a creditor waiting in the wings, the creditor could take it. If they have a troubled marriage, it's potentially marital assets if they put it in a joint account, and it's susceptible to the claims of the spouse in a divorce. In addition, if the beneficiary themselves is not a careful spender, then that money goes. It is gone, and that's the end of it. There's no more money coming their way, and if they need it, there's nothing to tap into. And people are fairly desperate. So outright is not really my usual recommendation, except for people who are wanting to keep things extremely simple and they don't have a lot of money. Then I will usually cave and let them go that route. What I would normally suggest is to get a trust set up and put it with separate trusts for each beneficiary. Here's my reasoning. Once you set up a trust for a beneficiary, if you have multiple beneficiaries, then if you start treating beneficiaries unequally, then they're going to have a potential issue. So if when you die, you end up with separate trusts for each beneficiary, then if you have a beneficiary that needs money for a house, they can get money from a house and it's not going to impact the other beneficiaries. So this way, they're each provided for separately. Nobody has to deal with each other unless, of course, one of them is a trustee, but they don't have to be impacted by the income or losses from another sibling's or other descendants' trust. When you set these trusts up, you're going to want to incorporate certain provisions into it. You want to make sure that there is a spendthrift provision in the trust. There is absolutely no reason that a trust would not have a spendthrift provision. What this provision says is that a beneficiary is unable to pledge their interest in the trust as collateral, and it also provides the ability for a trustee not to pay out to a beneficiary if the beneficiary is having an issue. It really depends how the provision is written, but at the very least, it keeps the beneficiary from doing anything really stupid with the trust. So what's an example of that? This is the one I always give to my class that I teach, the paralegals. If the beneficiary is a beneficiary of a trust and they go to the Ferrari dealership and tell the Ferrari dealership they want to buy a Ferrari, they don't really have the cash in the bank, but don't worry, I'm a beneficiary of a trust. What the spendthrift provision allows is that that beneficiary cannot use that trust as collateral. So they would not be able to get that Ferrari pledging the interest of the trust. So it's a great provision to have. It's, in my opinion, malpractice for it not to be in every trust, with the caveat that if you are creating a revocable trust, which is really just for your benefit while you're alive, and you can change it and use all the money, the spendthrift provision will not benefit you as the creator of the trust. It will only benefit future beneficiaries after you pass. In addition, you always want to keep abreast of who your beneficiaries are, and at least while you're alive, you're able to do this, and after your death, it's really up to the trustees. What are they doing? How do they spend? How are their relationships? Are they addicts? Are they gamblers? You need to know these things, because if you know them, then you know how to plan for them. And if you do what I'm suggesting in terms of trusts for them, then you can set it up that the trustee will have control, and the trustee will be able to essentially save them from themselves, whether it's suspending any distributions while they're in an addictive state or in a bad marriage. They may be able to circumvent by paying certain things directly so that the money doesn't go in the beneficiary's hands. They may be able to pay for rehab if the beneficiary needs it, so they're not on the street. There's a lot of different things that they can do if you keep it, and we're going to talk about discretionary on the next slide, but if you keep your estate plan very flexible, you're going to put some people in charge who are going to be able to protect your children and your grandchildren and future generations from themselves and from bad circumstances they get into. Lastly, and this is more of an estate tax thing, what you may want to do is skip your kids, at least partially, in terms of inheritance. Maybe you want to jump over the children who may be in good enough shape, or they're in such bad shape that you don't trust them, and leave money directly to descendants that are not, below your children, grandchildren, great-grandchildren. With that said, there is an additional tax that's imposed called a generation skipping transfer tax. Under the IRS code, if you are skipping your children and your children are actually still alive. So when you do your planning, you want to make sure to keep that in mind. There's a large exemption. Right now it matches that over $11.5 million. Again, that could change. So when you're doing your planning, you want to make sure to combine your tax planning along with it and know what your planning is going to cause in terms of potential taxes down the road. But a lot of times it's a great thing. You just skip the children because they don't need it. And if you left it to your children, then it would be taxed again in your children's estate. So this way, if you can skip over the children who don't need it, go straight to the grandchildren, you'll skip some inheritance tax later on. So what I've been talking about a little bit is something that's very important to me. It's important from an asset protection standpoint. It's important from an estate planning standpoint. And that is all about making trust distributions discretionary instead of mandatory. So when I gave you that example earlier about leaving money directly to your children, grandchildren, or any other beneficiaries, which means you die and they get it immediately, that's called a mandatory distribution. The trustee is required to pay it. or a personal representative if it's done under your will. It's a one and done situation. They get it. It's no longer controllable. Once they have it in hand, whatever they do with it, they do with it. The flip side is to create a structure where you're making everything discretionary. That means you're leaving somebody in charge as a trustee who is going to make the decisions as to what will be distributed to those beneficiaries. So it may be that the trustee is given total discretion, which means they can decide for any reason to make distributions or not to make distributions. It may be that the trustee is given discretion that is limited to a standard of health, education, maintenance, and support, which is a very broad discretion, but it's not 100% discretion. So depending on the beneficiary's lifestyle, it may, or quality of life, it may not encompass allowing a beneficiary money to take a cruise around the world, but it may allow them to get just a regular vacation. So if a trustee has the power of health, education, maintenance, and support, which is a standard, they just have to be educated, and if they have any question, they should ask their attorney before making a distribution. But most things are okay. You can pay a mortgage, you can pay for food, you can pay for utilities, for education, for enrichment, for after-school activities, for camp. So there's a lot of things that are included. So it's going to depend on who our trustee is, what the relationship of the trustee is to the grantor who created the trust and to the other beneficiaries as to what discretion we can give them. So if they're an immediate family member, then they are not considered an independent trustee, and discretion can only be exercised under health, education, maintenance, and support. On the other hand, if you have an independent or disinterested trustee, someone not closely related, meaning they're not a descendant of your grandparent, so they shouldn't be your aunts or uncles, but they can be, they might be able to be, well, it shouldn't be a descendant of your parents, so you can't have your siblings. You might be able to have aunts and uncles or cousins. It just depends on the situation. You want to carefully evaluate who would be a good trustee. Ideally, it would be somebody completely unrelated to you. And I understand a lot of people have some trepidation about naming people as trustees because you're giving them a lot of control. But you have to evaluate what's the long-term goal. And if the long-term goal is to protect your beneficiaries, then sometimes you just have to have a leap of faith. And you have to put in provisions that allow for trustees to be changed and to be monitored. For instance, what we call a trust protector or a trust advisor, you can put somebody in place in that role who is in addition to the trustee, who would have certain powers to oversee the trustee and oversee the trust. Maybe they have the power to authorize and rubber stamp investment decisions of the trustee. So it's a checks and balances system. They may be able to change the trustee. They may be able to make amendments to the trust that's otherwise irrevocable to account for changes in tax law, to correct scrivener's errors, to create special needs trusts if you end up with a beneficiary down the road who is disabled and receiving government benefits. So I like to include a trust protector, an independent trustee, and a regular trustee in my trust. What I like to do is if the client can't come up with names for an independent trustee or a trust protector, that's okay. I just put in a provision that allows such people to be chosen and incorporated later on. So as long as you have the provisions in there, you have long-term flexibility. Lastly, when you do a trust that has discretionary provisions rather than mandatory, the trust is going to last a lot longer because you're not just straight distributing things out. You're only distributing when somebody needs it and the trustee determines that it's a good idea to distribute. So you could really benefit many generations as long as you're in a state that allows a trust to last for many generations. And there are limitations. It depends on what state you're in. In Florida, you can go 360 years. So we have a very long statute. Places like New York, California, Texas, surprisingly have a very short statute. And there's others in between, and there are some that are even longer. I believe there are certain trusts in Wyoming that can last 1,000 years. So when you're planning, and if you have a great deal of money, you could really benefit generations for a long time to come. So those are things that I would definitely incorporate in my trust. 95+% of my trusts have these provisions, that have the discretionary provisions in them. It's only if a client really fights me on it and they don't have a large estate that I will agree to mandatory provisions, because I really don't see a benefit to it. Because even under discretionary, you could theoretically distribute out the whole trust if the trustee thinks it's a good idea. Okay. So we've talked about beneficiaries in general. Let's concentrate a little bit on the spouse right now. So let's say you are doing your planning and you've listened to me or some other attorney who's giving you advice on making things discretionary. You might have several trusts set up after your death to benefit your family. You can decide that at your death, only your spouse is benefiting until the spouse dies, and after the spouse's death, your descendants will benefit. Or you can create a structure where your spouse can benefit and your descendants can benefit. But what you want to do, if you're in an estate tax situation, so at this point it would mean your combined estate with your spouse is over $23 million, you probably don't want to pay estate taxes that might be due until after your surviving spouse dies. So in order to do that, you're going to have to use some sort of marital deduction planning, something that's permissible under the IRS code. One of the things we can institute is called a Q-tip trust, and everything when you're talking with taxes is an acronym. So the way the Q-tip works is you set up a trust for your spouse, which mine you can do during your life or to trigger at death. You put assets in the trust. The trust must pay any income that it earns out to the spouse. Every year it has to be distributed. It cannot be accumulated, and no one else can get that income. You can also allow for principal distributions to be made to your spouse, and you can limit those, or you can make it more broad. What the advantages are here are, number one, it avoids paying estate tax on the first death, because anything in this Q-tip trust is going to be taxable under your surviving spouse's estate when they die. Number two, it provides for the spouse, and the spouse can be the trustee. And finally, if there's anything left over in this trust, then it will go back to whomever you named as beneficiaries, which means if it's a second marriage, you're basically safeguarding what's left for your children, as opposed to it going to the spouse's other family. So you're allowing your spouse to be taken care of, but you're controlling the ultimate disposition of the money upon the surviving spouse's death. And if you use the health, education, maintenance, and support standard, even if you're making the spouse a trustee, if that power was discretionary, the spouse's creditors are not going to be able to reach the principal of the trust. They can reach the income because it's a requirement that the spouse gets the income. So it's really considered a mandatory distribution, and therefore you can't really protect the income. One way to protect the income would be to actually hold assets in the trust that don't produce income. So for instance, you might have vacant land that's just an appreciating asset in the trust. The caveat is your spouse has the right under this type of trust and must have the right, it's required, to what they say convert the non-income producing property into income producing property, which means the spouse has to have the right, whether they're the trustee or they have to order the trustee, to sell the land and buy something that's going to produce income. So if they don't need the income, they might leave it as just an appreciating asset. If they do need the income, they have the right to make sure the assets in the trust are going to produce income. Another option we have is something called a spousal lifetime access trust. And very often you see this, I'm not going to call them reciprocal trusts, one for each spouse, because they do have to have some dissimilar provisions in order for the IRS not to be problematic with this. But they're going to be substantially the same trust. I would set it up for my spouse would set it up for me, and essentially what it allows is for me to benefit from those assets and to be a trustee in my spouse's trust and vice versa. It allows us to keep things from each other's creditors, and it potentially has some estate tax benefits down the road. You can also incorporate a lot of the things you talked about in terms of discretion to really benefit the beneficiaries and keep the creditors away from the trust. So there's a lot of different things that can be done. All these trusts can be combined with ownership in LLCs and partnerships and other types of protected entities. We don't have a lot of time, so I'm going to kind of breeze through this. You're doing estate planning for two different times in your life. One, while you're alive but maybe incapacitated, and two, when you pass away. We've pretty much covered what happens when you pass away, but while you're alive, you also have to be conscious of what happens if you're incapacitated and can no longer manage your assets. So you want to make sure you have a good, durable power of attorney and you've got somebody trustworthy named as an agent. You want to make sure, as I mentioned earlier, that you have the document that allows you to pre-choose your guardian, because that's the person that's going to be making some very important decisions about your life, including, where you live and what kind of care you're getting. You probably want to have a revocable trust because it's easier for your successor trustee to take over than even an agent under a power of attorney. You certainly want to have an asset protection plan already in place. And you want to really have a bunch of insurances, because you want to, if you're going to be incapacitated and you're not able to work, you may want to substitute your income, have some sort of income stream coming in. So that would be disability insurance. You may need long-term care to cover the cost of home health care or a nursing home. And if you have life insurance with cash value, you can borrow against that, and that can bring money into the household. So incapacity is really just as important as what happens after your death. And the last topic I wanted to briefly discuss is estate planning for your business succession planning. Very often, at least until the last 6 weeks, your business was the most important and most valuable asset that you had. It's what provided your family with income, and it could be your legacy to your children and grandchildren later on. So you need to plan what's going to happen if you die. If you are the core of your business, then when you die, that business dies with you, which means no more income stream, which means no asset. And if that business can't be sold immediately after your death for a decent amount of money, then every day after your death, the value of that business decreases exponentially. So it's very important to plan accordingly. So if you have a business, you need to make sure that you have a plan in place. Is it that you have a key employee who's going to be able to take over and maybe buy out that business? Do you have a buy-sell agreement? Do you have life insurance securing that? Maybe you have a family member who's in the business or is willing to come into the business and can take over, in which case you have to plan for that in your estate plan, because if one child is going to get the business, then the other children need to be allocated other assets and not the business. Or maybe you're going to have one child run the business for the benefit of everybody else. That's also a plan, but you need to make these decisions. If you leave everything to somebody else to decide, this could be the biggest waste of assets that you've ever seen. So you need to make sure that you're doing business succession planning. So that we call estate planning for your business. I know today was a lot of information. I hope that you enjoyed today's webinar. If you have any questions on anything I spoke about today, please email info@assetprotectionattorneys.com. If you have any topics for future webinars, I'm always looking for topics relating to estate planning or asset protection or anything we can loosely tie to that. So I would appreciate that. Our next webinar is on May 21st at noon. I don't know what the topic is yet, but if you are on our newsletter, you will ultimately get the topic emailed to you in the newsletter. Good luck, everyone. Stay safe, and please feel free to contact us if you have anything that you think we can help you with. Have a great rest of the day.